I think we are set. Everybody should be online, listening, ready to go. Sorry for the short delay as we got this presentation going and sorted out a minor technical issue. We are all set. Thank you very much for joining us, spending your lunch hour with us. If you have school-age kids that are off for the day and are still able to join us, kudos to you. Gather them around. I'm sure they'll enjoy the presentation as well. Today's presentation, we are talking about some essential legal issues for real estate agents and brokers. And we have three things on the agenda. And we're going to start off with Mike DeLuisio. He is in Kelly Santini's West End office on Carling, and he's going to be talking about real estate transactions when you're dealing with divorcing or separating clients, and legal issues when you are involved in an estate sale, either buying or purchasing. And then we will turn things over to Sean Jabro-Lansar in Elgin Street office. Sean is an insurance lawyer, and he's going to be talking about preventing professional negligence claims. Before I turn things over to Mike, just two quick short things. First off, the slides from today's presentation are available in the control panel, and you should be able to download them. And number two, if you have any questions that you would like to pose to our two presenters, then please just type them in using that control panel, and we'll save some time at the end of the presentation to address them. And right now, we will turn things over to Mike.
Thanks, Keith. Happy to be here, everyone. Looking forward to speaking with you all today. So we have basics, kind of a high-level discussion today about some issues that you're going to be dealing with as realtors. Okay. Keith, if you're there, if you could help me with taking control of this once again. Excellent. So I'm just trying before we start to be able to take control of this to be able to.
Should be good now, Mike.
Great. So a little bit about me to start, everyone. I'm a partner here at Kelly Santini. I deal mainly with residential commercial real estate, also business law, estate planning, and estate administration. For those of you not that familiar with Kelly Santini, we're a full-service Ottawa-based law firm with two different locations, one at 160 Elgin, another one on Carling Avenue in the West End. So again, very excited to be starting off with you guys today. So here's our outline. So first, we're going to be dealing with divorcing and separating clients, specifically a little bit about the Family Law Act, and then really importantly for all of you, who is a spouse, a matrimonial home definition, and then listing and selling matrimonial homes, so things that you need to be aware of. We're also going to speak a little bit about estate sales. So who are you going to be dealing with? Getting a certificate of appointment of estate trustee, which is commonly referred to as probate, timelines, and ways to protect clients, and I mean also yourself. So let's jump right into it. So the Family Law Act, there's been a number of changes generally in recent years. There's certain protections that are set out in the Family Law Act for people deemed to be spouses under the Family Law Act. So according to Section 1 of the Family Law Act, a spouse means either of two people. So one, people who are married, okay, being legally married, ring on a finger, or people that have entered into a marriage that is voidable or void, but in good faith, okay? That's going to be very infrequent that you're going to see that. We're really concerned with for the purpose of our presentation today, so people that are married to one another, and that's what spouse means. So who is not a spouse? So for our purposes right now, under the Family Law Act, Section 1, common law partners are not considered spouses. Okay, so again, unless you've been legally married or an avoidable marriage, as we've talked about, you are not considered a spouse under Section 1 of the Family Law Act. Engaged couples, people that are going to be married, are not yet spouses. Friends, roommates, your baby's mom or daddy, they're not considered to be spouses. Okay, so that's a very important for us to realize what this definition means. Now, moving on now, what is a matrimonial home definition? Okay, because we hear that term all the time. Well, Section 18 of the Family Law Act says that every property which a person has an interest in, or if the spouse is separated, was at the time of separation ordinarily occupied by the person and his or her spouse as their family residence, is their matrimonial home. Okay, that's a little bit wordy. So my translation for you is, if you are legally married and you regularly occupy it together, it's a matrimonial home. Okay, if you are separated and it was regularly occupied at the time of your separation, it is a matrimonial home. Okay, and we'll see in a little bit why that's so important that we recognize what the definition is and, again, what we need to do. So why do you care if the property is a matrimonial home? That's really the crux of things. Why does this matter to us? Well, you care because Section 21 of the Family Law Act states that you can't dispose of or encumber, really meaning mortgage, an interest in a matrimonial home unless the other spouse joins in the interim, so again becomes part of it and consents to it. The other spouse has released all rights by a separation agreement, a court has authorized or directed it, or the property is not designated as a matrimonial home because they have registered a designation on another piece of property, confirming that this is the only matrimonial home that they have. Okay, so this is why we care. You cannot simply deal with a matrimonial home unless one of these four things have come into play. So what do you have to do? Okay, as a real estate professional, what are your obligations? What should you be doing to make sure that you're not getting into trouble and to make sure that your clients are in compliance with the Act? So if you're listing a house, you have to determine these four things. So one, who is on title to the property? That part's easy enough. You should be able to find that quite easily on Geo Warehouse. What is the spousal status of each owner? So it's incumbent upon you to speak to your client and to find out, hey, are you married right now? Oh, you are. Okay. Does your spouse, are you separated? Are you currently married now? If any owner is a spouse, we have to start to determine, is the property a matrimonial home as defined in the Family Law Act? So you have to say to them, is this a rental property? Is someone else living here right now? Are you living here? Does your spouse ever live here? You need to be able to ask the appropriate questions so that you can determine what you have to do, which is number 4. So if the answer is yes to any of these, how are you and your client complying with Section 21 of the Family Law Act? Many times people get this wrong. So we see agreements land on our desk that have not been signed by a consenting spouse. And we're saying to our clients, well, let's hope that we can get this consent because you've entered into an agreement to deal with this property, but we can't complete it for you because you can't comply with the Act. So it's really important that you get that sorted out because, again, you can enter into an agreement, but it doesn't mean that you've entered into it that you're legally able to complete the sale, and there means there can be liability there for potentially you, but certainly for your client. So in terms of things that you really want to remember is anyone listed on title should always be signed the agreement of purchase and sale and listing agreement. That's a no-brainer. Okay. If you're on title, you should be doing it. Anyone who's a spouse, you need to at least ask the appropriate questions. People can potentially have more than one matrimonial home. You could have 2 homes that you're ordinarily occupying, each on a part-time basis. Okay, so you need to ask those questions. There is the possibility that an argument could be made that either one or both of properties are a matrimonial home. A separation agreement must state that the spouse releases all rights to the subject property. It's not enough to just have a separation agreement in place. And if we do have a separation agreement, we need to take a look at it because does it just say that it's released, or does it say that upon a certain amount of money exchanging hands or other things happening, then all rights are released. So that's very important to note. To have it really be released, it needs to say that at the time of signing the agreement, all rights are released. Okay, if it just says upon certain payments or other matters being done, well, that doesn't mean that they now have the right to do it. We have to determine whether or not all of those other conditions of the release have been met. Okay, a couple other items for us to remember. The definition of spouse is different when determining if someone is a spouse for land transfer tax purposes or various other purposes. So when you're talking to clients about whether or not, they have a first-time home buyers land transfer tax exemption, or whether they can use their RRSPs, for example, these are all potentially different tests. And before you're giving them any definitive advice, you want to, perhaps direct them to the appropriate parties that should know. So let's take land transfer tax, okay, for our situation today, because that's what we deal with here when we're completing real estate transactions. So Part 3 of the family law expands the definition of a spouse in Section 29, which is probably the definition that we're all now more accustomed to, and it states that you're considered a spouse if you're not married to each other and you've been living together, cohabitating continuously for a period of not less than 3 years, or you're in a relationship of some permanence if you're the natural or adoptive parents of a child, okay, aka your baby's mommy or daddy. So that now expands the definition, okay, but that is not applicable to our matrimonial home, although it can be applicable to certain things, such as when you're trying to make determinations about whether or not someone qualifies for a first-time homebuyer's land transfer tax exemption if their common law spouse already owns a house or has owned a house. Okay, so again, there are different definitions and they apply in different situations. Okay, that pretty much summarizes, like I said, at a kind of a high-end level, what we need to be thinking about when dealing with matrimonial homes and again, people that are being divorced or separated. The second half of what we're talking about deals with selling property when someone is deceased, so estate sales. These are special and they need some special wording in a lot of the agreements, and we do see problems arise frequently because they again, are unique, and there seems to be a misunderstanding many times about what can and can't be done. So looking at our slides here, what is an estate sale? Well, it's really just the sale of property which is owned by a deceased person, which is the estate. And as I mentioned, it presents some pretty unique challenges for you as realtors. And again, you may be dealing with one or more estate representatives, which can further complicate things for you. Okay, so common question, and we get this a lot, is, as a realtor, who do I deal with? Well, the short answer is that you are entitled to deal with whoever is named as an executor or trustee in the deceased will and has the authority to act on behalf of the estate. So what should you be doing to ensure that you are dealing with the correct person? Well, you should be asking to see an original will. There's a reasonable chance you're not going to have access to the original will, so you want to ask then for a notarized, true copy of the will. Okay, so that you know that one is in existence and that it's been notarized and that what you're looking at is a true copy of what it is. You're also going to want to ask for a death certificate, okay, which is perhaps a little morbid, but really a will is no good if the person who's written that will is still alive, right? It only comes into force when the person who's written it has passed away. So you want to make sure that that person is actually dead. And a death certificate is the way that you verify that. Once you have that will, once you have the death certificate, well, then at that point, you should be able then to deal with that person and know that they should be having the authority to act on behalf of the estate. Note that if there's more than one executor named in a will, then both of those executors are going to have to agree to decisions made, okay, subject to anything else that the will says, okay, such as if there was three, if it was if there was like majority rules, for example, there an argument could be made there. But really, let's say there's two executors, which is the most common. They would need to sign everything together, which means agreements, waivers, listing agreements, etc. You're going to want to have everyone who's listed as a trustee signing off on all documentation. Now, what if there is no will? Again, this is pretty common. We see people dying intestate all the time, and this poses some further challenges for you. So if someone dies and they do not have a valid will in place, they're dying intestate. And in order to become authorized to act on behalf of the estate, you have to apply to a court in order to be assigned as the executor trustee. So this is referred to as obtaining a certificate of appointment of estate trustee without a will, okay? Commonly referred to as a probate certificate. If there is a will, then it's just simply called a certificate of appointment of estate trustee with a will. But again, people commonly refer to this as a probate certificate. When the person does not have a will, they're going to require this certificate to verify that they are authorized to act on behalf of the estate. If you do not have that document, there's not a guarantee that you're going to be authorized to act on behalf of the estate. And my suggestion would be that if it is an intestate estate, you want to wait until they have that document, because that is the confirmation that you are dealing with the appropriate person. Okay, so only the person with that document really has for certain the legal authority to act on behalf of the estate, although there is an assumption that a spouse will have the authority to do so. So you can assume that a spouse will have it, but again, it's not a guarantee, because technically you do need to have that document in hand. So here's a scenario for you. So your client says, great news, or rather, you hear someone say, great news, my client has a notarial copy of a will, and they're the executor. We found a buyer. They want to close in 2 weeks. Can we do this? So if you're asking this question to me, what sort of response are you going to get? Well, my answer to you is, unfortunately, not likely. Okay, an executor can enter into an agreement to sell a house, but you cannot complete the transfer until the executor has obtained this certificate of appointment of estate trustee, and we're going to call it a probate certificate moving forward. Okay, so even though they have the will, you cannot physically close the transaction and transfer ownership until you have that. The only exception is called the first dealings rule, which is very rarely, if ever, used, which means that the property hasn't been dealt with since it's been converted into our land titles. And again, that's just so highly unusual that we rarely see that. So your assumption is that you need to get the estate, you need to get rather the probate certificate in order to complete the transaction. Estate sales take time. They just do, they lurch along, and you have to be prepared for that. So how much time do they take? Well, once an application is completed and filed, which in and of itself can be quite time consuming, because the executor has a lot to do, like locate all of bank accounts, assets, estimate or get evaluations for what the value of certain assets are. Then you need to typically have a solicitor prepare everything. So that in and of itself can be long. Once that is done and you've submitted the application, I tell people to expect an absolute minimum of 3 weeks. And I would suggest to you, okay, this is not scientific, but average time is probably 4 to 8 weeks, assuming the application is accepted. Lots of times applications can be rejected for various reasons, in which case you need to resubmit, which can cause a further delay. Okay, and so assume that it's going to be several months to get this. And again, sometimes years to administer, although not necessarily to get the application. So just long and short of it is, assume that it's going to take some time for this to happen. Now, how do you protect your clients then? Well, when listing a property, you're going to want to do a couple things. So one, you're going to want to have conditions in the agreement of purchase and sale that one of the conditions is your client obtaining a certificate of appointment. Okay, and you're going to want to have some finalized timelines saying, if we can't get it by this date, do we have an ability to extend? Who gets to choose the new closing date? How far can you extend? And I always suggest that there should be at some point some drop dead date, basically, pardon the pun, but some date that says, look, if we can't get it by this, then we can just terminate this agreement and no one's liable. Because you can't just have something go on in perpetuity in the event that something happened and a certificate was never obtained. Watch out for an SPIS. We're not seeing a lot of those anyways now. But keep in mind, it's pretty difficult for a seller, being an estate trustee, to to fill out an SPIS in any meaningful way because they likely don't have any real information or knowledge with respect to the property. Family law considerations. Was the deceased married? So you have to go through all the same questions that you would normally for a client to find out if we have a spouse, who has a right to, some of that property, would have to consent to it being sold. You actually have to look to the residency of executors, because when you have an estate, if the executors are non-residents of Canada, that can mean that the estate itself is a non-resident. And that's something to be aware of and to let your solicitor know. And then lastly, you want to make sure that insurance remains on the property. Not that it's your responsibility per se, but I think it's a great item for you to bring to their attention as a value add to say, hey, make sure you have insurance on the property. Make sure if it's vacant that you've advised your insurer that it's vacant, and they're going to tell you what you need to do to keep your insurance in place. Okay. And the same thing goes for residency. Not necessarily that you're obligated to do anything, but I think it's a great value add for you to say to someone, hey, you may be a non-resident, talk to your solicitor about that. So those are sort of the 5 points for listing a property. Now, how about when buying a property? Well, kind of the same things apply. One, conditions in the agreement. You want to have a condition in there for obtaining a certificate of appointment of estate trustee. And then again, importantly for you as a buyer, termination dates. Okay. Do you still want to buy this property if it takes a year for them to get it? You need to negotiate whether or not you are the one that has the ability to extend to another date, or whether or not it's your seller who has the ability to terminate if you can't get a probate certificate by a certain date. So my takeaway that I want you to have is you need to have a condition in for this. You should have finalized dates, and you need to negotiate who has the ability to finally terminate if you cannot get one by a certain date. Lastly, final walkthroughs, particularly on vacant properties. Because you don't have someone actually living there, we see way more issues with there being something wrong at the house, because they're typically vacant at the time of sale. So whether it's leakage or something happening. So I normally suggest that you want to have a walkthrough the day of or the day before to ensure that nothing's happened at a vacant property. And again, this may be obvious to some of you, but lots of times we don't see it. So those are the 2 tips that I have for you in terms of protecting your clients when buying an estate property. Okay, so that's it for me. I'm passing it along to the very handsome Sean Jabberlancer, very knowledgeable Sean Jabberlancer as well, and I look forward to answering some questions from you afterwards.
Well, thank you, Michael, and good afternoon, everyone. And thank you for that fine compliment, Michael. So my name's Sean Jabberlancer. I'm one of the litigation associates at Kelly Santini. I work in a variety of different litigation groups, but primarily insurance defense. And one of the areas that I practice in is with respect to RICO claims when actions are commenced against realtors. Sometimes we're not at the action stage when we get involved. It's prior to an actual statement of claim being issued. And that'll be one of the points that we'll be discussing is when do the lawyers get involved? But overall, this is the point of the presentation is how to avoid professional negligence claims and how to avoid getting sued. So presentation outline, first thing we're going to be talking about is what to do if you receive a demand letter, claim, or think that a claim is in the pipeline. Then we're going to go over some of the more common types of litigation commenced against real estate agents, and some general tips, comments to avoid claims against realtors. Now, first thing, you get notice of a claim, either by way of a statement of claim or an email from a lawyer, or you feel that the entire matter is going off, your client is unhappy, or the other side is threatening legal action. What should you do? First thing is always to ensure that the broker of record is aware and apprised of everything that's going on the file. If there is any indication that the file might be going towards litigation or that there's an unhappy party, it's best to involve the brokerage immediately if they aren't involved already as it is, and then contact RICO. it's very easy to make a claim with RICO, and that doesn't necessarily trigger a claim, but they have to be made aware. And one of the requirements in your policy with RICO is to advise the organization as soon as possible if there's any prospect of a claim. The next thing that's very helpful, when there is a claim, RICO retains a lawyer to defend your interests and the interests of the brokerage. And the first thing that I want to do once I get a claim is to get a timeline of all the relevant events and for you to gather all documentation, email, text messages, everything to do with the file. So if you have an organized file and you have all of your documents already in the file, that makes it extremely helpful. But if something is going off, it's a great idea to get a timeline of events prepared, so that if you're meeting with your broker of record, if you're speaking with someone at RICO, you have this timeline prepared with all your relevant documents ready to go. Now let's go to actual claims and what kind of claims I see. I've defended dozens of realtor claims, and probably usually what happens is they are commenced in negligence for misrepresentation. Now, it's also possible that an action is commenced for breach of contract against an agent, but usually the vast majority of claims are where an agent is held liable to a vendor or purchaser for negligence. Now, what is negligence? As a real estate agent, you owe a duty of care to your client, and that duty is measured by the standard of a reasonably competent real estate agent. Now, to succeed in a claim for negligent misrepresentation, a claimant needs to prove that there was a duty of care, so that there was this special relationship between the agent and the client, either the purchaser or the vendor, that the agent made a representation that was untrue, misleading, or inaccurate, that you were negligent when you made that misrepresentation, that the other side relied on that misrepresentation, and due to that reliance, they ultimately suffered damages. Now, this is a very legal breakdown of this. What's important to take down is that the majority of the time, it's a misrepresentation that was made by the agent, the other side relied on it, and ultimately they suffered damages. For example, someone says, this basement is excellent. There's never been any issues with this basement. The other side relies on that representation. It turns out that representation was untrue, and ultimately the purchaser suffers damages. So let's move on to the most common ones, and that is exactly the most common kind of file that comes across my desk is leaky foundations, water infiltration into the property in one way or another. The potential purchaser goes to view a property. There are no issues at the time with the property. When they obtain possession of the property, shortly thereafter they discover defects, and they look at the other parties to rectify the damages that they've incurred. Michael commented on SPISs. There are many issues with SPISs, and I'm assuming that the majority of you are not using SPISs. If you are, there's an entire area of law on this point, but be aware that they're very risky and they open up all kinds of other potential claims. Now, with leaky foundations, what's the most important thing? And I repeat this many times whenever I meet with agents, and I hear it from brokers that they're constantly advising their agents. It's very important that you paper your file. Most cases that get to litigation take years, so we're really relying on that paperwork because by the time it gets to my desk, it's several years down the line. memories fade. I ask agents, well, they're alleging that you said X, Y, or Z, and they say, well, I would never say that, and I can assure you I never said that. But there's no email or correspondence or text message or anything to confirm that point. And people will convince themselves that something was said even if it wasn't. So they might think that discussion took place, or they might misunderstand something that you said. So it's very, very important that you put it in paper, send an email, and it will definitely save a lot of headache down the line. So when you have a potential vendor, the most important thing is to highlight the importance of disclosure. Now, I'm of the view that the more disclosure, the better. If there's anything of concern, disclose it to the other side. Even if it's very evident and they walk into the property and it's very evident, I would disclose it. There's no, even if it's completely visible, it's better to disclose it and prevent the allegation that something was withheld or something wasn't shared with the other side. Now, a caveat here is that be very mindful of situations where you are double-ending a deal, and make sure that you properly document the file and disclose information so that there's no allegation that you withheld key information that was in your possession from one side to the other. You're not a home inspector. Most of you, I assume, are not home inspectors. Don't make any comments about the foundation's structural integrity. Don't guarantee, warranty any aspects of the property. It sounds self-evident, but it happens very often. By the time I get the file, the allegation on the other side is that, well, my agent told me that the basement is excellent, that these basements never leak, that they've sold 100 of these properties, and that there's never been any issues. Don't warranty any aspects of the property. That's not your job. And encourage them to get a home inspection. And if those questions are put to you, push it back onto them to get a home inspection and to retain a qualified expert to provide comments on that point. Now, if you have any concerns, raise them and document them. If a client is going against your recommendation, get it in writing. A lot of the times, a lot of the work for agents is done by telephone, and when I get the file, they tell me everything was moving very rapidly. I didn't have a chance to send an email. Timelines were really tight, and I certainly had this discussion with my client, advising them X, Y, or Z, but there's no email or text message evidence to substantiate that point. It takes a few minutes. If there's anything that's of concern, or if there's any important discussions that are had by telephone, document it afterwards by way of an email, because it'll certainly save you a lot of headaches down the line. And one more point on that, you'll likely run into a situation with unethical clients where you advise them that they have a duty to disclose certain facts about the property, and they refuse to do so, and they instruct you not to do so. What to do in that situation? Walk away. They're not worth the headache, and it will almost certainly come back to bite you. So walk away is the best advice that can be given, and that's what's recommended by RICO. If you have an unethical client, walk away from the deal and advise them that you cannot continue with the transaction. Now, another issue that's been coming up more and more often are issues with the agreement of purchase and sales with condos. I've seen a few claims that were to do with the parking spots. People value parking spots immensely, and if they don't get the same parking spot that was listed in the agreement of purchase and sale, there's a different spot. Sometimes there's a typo. Sometimes the location and size of the spot that was shown to the potential purchaser is different than the one that they ultimately receive. It creates all kinds of headaches down the line. So it's important to ensure that the right spot is included, and that it's the same dimensions and everything that they saw when they were viewing the property. People have very large trucks, people have mobility issues. It can mean a lot to people if they get the wrong spot, and there have been claims with respect to these issues. Another one I see are Airbnb clauses, where a agent tells the prospective buyer that Airbnb is permitted when in fact it's not. The rules with Airbnb are changing shortly, so this one might not be as applicable, but it is important. If you are making comments about any of the bylaws or anything with respect to the condo, make sure that you know what you're talking about. If you don't know, don't comment. And that's applicable to the next point with pet policies. Even if you're certain that pets are permitted, tell the prospective buyer to do their own due diligence and get it in writing that they ought to confirm the details themselves. Don't make any warranties or guarantees about any policies. Even if you're almost certain or certain, put the onus back on the prospective purchaser to do their own due diligence. Now, another issue that's been coming up more frequently are language issues. When a party to the transaction's first language is not English or French, and they rely on the agent to act in and provide comments, advice, etc. I've seen it at discoveries or on files where the agent tells me, I went over every aspect of that agreement, purchase and sale in detail to ensure that they understood it. I went over everything. And then the other side says, I didn't know any of that. I trusted my agent. I didn't understand it. I didn't understand the language. I trusted my agent entirely, and they told me everything would be fine. How do you address that? If the person is Francophone and the paperwork is in English, try and have a French agreement of purchase and sale. If possible, if the agreement of purchase and sale is in English for whatever reason and there's not a French copy, provide them with a blank French agreement of purchase and sale so that they have the opportunity to look through the clauses and understand all of the materials, all the clauses that are in the agreement. So give them that sample French APS, but ensure that they understand the content, and again, confirm this in writing. Highlight any of the exclusionary clauses, any of the conditions that are listed in the agreement of purchase and sales schedule, and again, confirm it in writing that they understand what the consequences are. Now, if the person doesn't speak English or French, and let's say it's an Italian agent who has an Italian client who doesn't understand any English, it might be prudent to hire an interpreter. And that's one of the recommendations from RICO, is to avoid the headache, have an independent third party come in and hire that interpreter and have something in writing in whatever language it is that confirms that they understand and they're in agreement to proceed. If you have any doubts about any aspect of the file, send an email. And it's incredible how many times I hear it from an agent. I had a bad feeling about that particular client. I knew that they were going to try and screw me. They were just a little bit shady. Something was off. Confirm everything in writing. And as lawyers, we have to do the same thing. We call it cover your butt emails, cover your butt letter. Send an email confirming the discussions that you've had. It only takes a few minutes, a few seconds to send that email, but it will definitely save you a lot of headache in the long term. Now, latent versus patent defects. Quick definition is there. Latent defect, a fault that would not be readily revealed by reasonable inspection, and patent defect, defects that are not hidden and should easily be discovered by reasonable inspection. Now, if there's one takeaway, disclose. Every year there's more and more litigation that's commenced against real estate agents. We're seeing more and more claims, and it's becoming more and more common for any kind of issue with a transaction. All parties are named. The home inspector is named. The real estate agents on both sides are named. And the first thing I look for in the file is paperwork. And if there are paperwork, if there's email or letters or text messages that explicitly advise of what is needed to be disclosed, and the agent receives whatever information and forwards it onto the other side, it's really tough for them to make those allegations that you knew or misrepresented some information. So what I suggest, and it's in one of the next slides, is to have a standard email that you send to all clients with respect to their disclosure obligations, what information that you require, the importance of disclosure of all defects with respect to the property, and send it to the client in writing. And when you receive their response, if it's unclear, if it's ambiguous, follow up with them and highlight the importance that it is to disclose that information and get instructions to disclose all of that information to the other side. I've seen claims for hardwood floor defects, heating issues, HVAC, mold, permit issues with properties. It's a very long list of issues that come up. And if there's any possibility that there is a defect that's in the knowledge of the prospective seller, that they disclose it to you, and then you can make that determination of whether it should be disclosed to the other side. But even if the defect is very obvious, I would err on the side of caution and disclose it in writing to the other side. If it's obvious, they're going to see it, and there's no point in hiding it. Litigation is not a fun process to go through. It's a pretty brutal process overall, and I hope that none of you have to go through the entire litigation process. But if there is a claim, then that's why you have insurance and we're retained. But for your clients as well, it's a very stressful process, and I always highlight to all parties the importance of disclosure, because what you might think is not something, or the client might not think is something of importance, the other side might, and the other side might make a very big deal of a small issue. So avoid all of those headaches and disclose. And if your client's refusing to disclose a material fact, strongly consider dropping the client, and it's honestly not worth it. And again, get everything in writing. Another thing that I've been noticing, not as many claims, but this is something that's been coming up, and I just want to make sure that newer real estate agents are aware of the importance of deposits, and that if a deal does not close, to be very cautious about releasing deposits. I've seen lawyers explicitly write to agents to tell them the deal didn't close, you are obligated to release the deposit back to me, to our trust account. Please release it immediately. Do not listen to a lawyer who's asking you to release the deposit unless you have the proper documentation. The standard rule is only release a deposit if the buyer and seller both sign a mutual release, or by a court order directing the release of the deposit. And that's in situations where a deal doesn't close. But overall, don't release the deposit unless you have a release from the buyer and the seller, or else it will create a laundry list of headaches and a claim will get initiated. So avoid that step. Even if the lawyer is explicitly telling you as part of this agreement, if the transaction didn't close, then the deposit was automatically to be released. Even in those situations, RICO recommends that you get a release, mutual release signed by seller and the purchaser. Now, other claims that come up, this was just a short list of the most common claims, but claims in Ottawa are different than claims in Toronto or claims in Vancouver. Ottawa, we have a lot more rural properties, so water quality, quantity issues with well water claims do come up. Septic problems are certainly issues that we continue to see in Ottawa. In Toronto, there's a lot more claims with respect to the market, and then the drop in the market where people were trying to back out of deals and back out of agreements. Those were a lot more common in Toronto and in Vancouver. They're not as common in Ottawa. And another one that was occurring in Toronto and in Vancouver were claims where agents were selling a property and then had a second deal lined up to sell the property for a higher amount, and there were claims that the agents were not acting and were acting unethically and not trying to get the highest purchase amount for their initial client. We don't see those claims in Ottawa quite yet. The market here isn't as hot as it is in Toronto or Vancouver, but something that's certainly factor and to keep in the back of your mind when dealing on files. And the last one on that list is something that's not in the APS, but that the purchaser was told would be included in the sale. And after the fact, they're saying, well, I was told that this was going to be included and it was not. If anything is to be included, ensure that it's in the agreement of purchase and sale, and make sure that the parties are aware and are acquiescing to anything that's going to be included in the agreement of purchase and sale. So takeaways from all of this: organize your file so that there's a clear paper record, and have a practice that's a set practice where if you have a prospective someone who wants to sell their property, send an initial email that sets out the importance of disclosure, what they require to disclose to you, and if anything comes up, to let that they ensure that they advise you in writing. So if you send that email right from the outset about the importance of what it is that they need to tell you, if they don't tell you something, then you have a very good defense that you did seek that information and that was not provided to you. So if there was any misrepresentation, it was your client who misrepresented the information. You can't control what your client is not prepared to tell you. Now, if you go in the basement and the basement carpet is wet and they want to sell the property 6 months later, well, now you have that knowledge that that basement had leaked on at least one prior occasion. So that's something that's now in your in the area of knowledge that you control. So it's important that you disclose those kinds of facts to the other side. So send that initial email to sellers about the importance of disclosure, and follow up all telephone calls with an email. That's probably the next most important thing, other than papering all aspects of your file. If anything is disclosed, or if anything is told to you by telephone, follow it up with a quick email saying, "Hi, John, you told me X, Y, and Z," just putting it in an email so that we both have it in our file. Let me know if I misunderstood the conversation. And at least then you have it in your file. And it's a pain to constantly send these emails, but as a practice, you'll certainly save a lot of headache and time if a claim gets commenced. And I've seen files where a demand letter is sent saying, the agent, you were negligent, you misrepresented this information, X, Y, and Z. For these reasons, we're of the view that you owe our client $100,000 to repair the issues with the foundation. And we get involved, and before a claim is actually commenced, this is just in the demand letter stage, we're told that there's this nice email that the agent sent to the other side asking for disclosure, and the response that they received is, there was no issues with the foundation, there's never been any water infiltration. And later on we find out that there actually was, and that information, that was a lie that was told to the agent, and the agent only forwarded the information that was given to them, and the lawyer on the other side decides not to sue the agent and only go after the vendors directly for misrepresentation of material facts about the property. And in that case, that's not even misrepresentation, that would be fraudulent misrepresentation, because they knew and they fraudulently misrepresented material facts about the property. So again, get everything in writing and it'll save you a lot of headache. Follow up all telephone calls with an email. And if you have a bad feeling about a client, you do not need to proceed with that client. Tell them that you can't continue, tell them that you can't act as their agent, and you might lose out on a sale, but you'll ultimately thank yourself for not dealing with a character that can get you into a lot more of a headache than they're worth. So that's the general overview of how to avoid professional or negligence claims against real estate agents. But if anything ever comes up, please feel free. Don't hesitate. If it comes up with any of the facts that Mike was speaking about the estates or the family law, feel free to give him a call. And if anything comes up with questions about litigation, don't hesitate. I'm always happy to chat. Give me a call, and I'm happy to talk you through any questions that you have about a file or about any matter. So on that note, I'll send it back to Keith, and we'll see if there's any questions.
Thank you very much, both Sean and Mike. Let's get Mike back online, and we'll see what questions you might have. So on your control panel, if you do have any questions, please do send them in. Mike, here's a question for you. You had an interesting portion of your presentation talking about common law, or who is and isn't a spouse, and if there isn't a ring on the finger, it's not a spouse. Are there situations where it's a common law couple, but cohabitation contracts come in, or cohabitation agreements?
Well, we certainly see cohabitation agreements, but you can't, by way of a cohabitation agreement, agree to be considered spouses under Section 1 of the Family Law Act. So, so that would be my short answer on that one. You can't contract to be it. You have to actually be married, legally married. You can't just simply contract amongst yourselves to consider yourselves married.
Okay. And but if they're splitting and selling the house, then the cohabitation agreement comes in.
Sure. If they're splitting and selling the house, if you have a marriage contract in place, it could dictate effectively what happens, but that would be highly unusual for it to immediately say that this specific matrimonial home is immediately released and goes. I'm not sure that would. I don't want to comment on it, but I would have concerns about it. Let's say that.
Okay. Sean, you mentioned in dealing with clients whose first language isn't English or French, the idea of getting a translator in. Is there standard protocol for how that's done and who pays for it?
On the RICO website, the recommendation is to get an interpreter. There's no standard practice about who pays for it, but if there's a concern that the information that you're conveying to the client is not being understood, I would recommend bringing in a translator, and it might be a cost that unfortunately that you would have to incur. But an hour of a translator, usually they charge about $30 or $40, maybe $50 an hour, is well worth it, as opposed to a claim where they're going to allege I didn't understand all of this, et cetera, et cetera. So if you can get that interpreter to come in for an hour, sometimes they have minimum amounts, minimum time frames that they would have to come in for. It's well worth that investment, especially if it's at the stage where a transaction is going to go through, to ensure that they properly understand the paperwork that they're signing, and to give you the opportunity to get something in writing that they are receiving that says that they understand and that they're providing you those instructions to proceed.
Thank you, Sean. Mike, question: if there's no will and somebody has to apply to the courts to become the appointed executor, can the courts appoint more than one, and will agents then have to deal with two or more executors?
Yes. So the courts can appoint multiple executors. They do have the discretion to do so, and when it's not clear, like when there's not a clear choice as to who it should be. So when there's not a spouse, if there's multiple children, for example, that wouldn't surprise me at all. Wouldn't be unusual to have the court appoint more than one. Absolutely.
Okay. And you and I have talked about this before on estate planning and making sure your executors are local. If there's two or more executors and one lives in British Columbia, I don't imagine there's an easy way around it, and that's just something that slows down the process, getting two signatures on everything.
Yeah, correct. What's nice though for most of our listeners, I mean, everyone has, except lawyers, realtors all have access to DocuSign. So once you've been able to fulfill your identification requirements, typically signing those agreements or, NOFs or waivers, etc., typically not the end of the world. It becomes a little more of a process for actually closing when we have to meet them in person, or they'll have to sign elsewhere, or perhaps with, for some other items that would have to be done, like going to a bank or appearing personally to deal with some other items. But I feel like for dealing with the real estate, again, for our listeners, for realtors, I think it's probably not the end of the world, just because of the advent of DocuSign. You're able to get things back pretty fast.
Excellent. Thank you, Mike. And last question for Sean. It's a question about RICO and who hires the lawyers.
So that's a good question. So the Real Estate Council of Ontario, all agents pay their dues to the organization, and when there is a claim that's commenced against an agent, the agent has to report the claim to RICO, and then RICO's insurer then retains counsel. So if it's in Toronto, the insurer for RICO then retains counsel in Toronto, or counsel in Ottawa, or counsel in Windsor, or wherever it may be, to defend the agent and the brokerage, and to provide a defense on their behalf. Now, just on that one point, the first, we want to ensure that the agent is involved in the process, because if there is any potential for liability or negligence, then their deductible might be at play. And these are all discussions that we have in depth to ensure that the agent and the brokerage are fully aware. But the instructions that are being obtained are both from the agent and from the insurer, as they're the ones that will be paying the bills for the lawyers. So it's the insurer for RICO that's really the group that retains the lawyers for the action.
Excellent. Well, thank you. We have just hit 1 o'clock, so time to wrap things up. I want to thank everyone for tuning in today. Our apologies for the technical glitch right at the start. Thank you for sticking with us. If you haven't downloaded the slides, you can get them from the control panel, or if there's any difficulty with that, just drop us an email and we'll happily follow up today's presentation with a copy of today's slides. And we'll wish everyone a great rest of the day. Thank you, Sean and Mike, and so long for now.
Thank you, everyone, for coming in.
Thank you, guys.